Your cost for ammunition background checks today has gone up 400%. I also thought it would be a good idea to go back to last week's NguyenVBonta opinion, get a Second Amendment attorney's thoughts on it in conjunction with legislation that we have in California proposing a 3-gun-a-month rule. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we've got some new developments today. It is July 1st. There are laws coming into effect in California today. One of them has to do with the Second Amendment community. Along with a development that we saw last week, I thought would be a good idea to get a Second Amendment attorney's perspective on this. And to do that today, we have brought back Matt Caballero. He is a partner at Michelle & Associates. Matt, thank you for being with us today.
Thank you for having me again.
Absolutely. And guys, before we get into this today, please be sure to like, share, and subscribe to these videos. Throw your comments down in the comment section. It's all fuel for the algorithm to get this out as far and wide as possible. If we're going to keep pushing the ball forward on the Second Amendment movement here in California, we need to get this info out as far and wide as we can. So please go ahead and do that throughout the video when you get a second. Thank you very much. So Matt, let's jump into, I guess, the more prevalent thing that's happening today on July 1st. We have this law coming into effect that is a 400% increase in the background checks for ammunition. Now, I know that 400% sounds like a lot. It should sound like a lot. It is a ridiculous increase when thrown into application. That does turn from a $1 fee into a $5 fee. Matt, I thought that maybe we could just start not necessarily with like the foundation of the fee in general. I think the majority of our audience understands back in 2016, we had Proposition 63, which created these regulations for purchases and transfers for ammunition in California. That was the root cause for the ammunition background checks. You had the $1 check, which if you're already in the system, they could do a quick check, which we had a lot of problems with. And then they had the $19 check if you weren't already in the online systems. We filed a lawsuit. We've got Rhode v. Bonta, which is at the Ninth Circuit. I guess what I'm asking is the foundation for the change from $1 to $5. Can you kind of walk us through the process that we got here with and how it's now changing to $5?
Sure. So when the system was first launched, in order for DOJ to create the background check system that we now have, they had to take out a substantial loan from the state of California to the tune of about $25 million or so. And so that cost obviously is something that has to get repaid eventually in the form of a loan. And what DOJ originally did was they estimated what they would anticipate they would be generating as far as income from the system for these checks that they have to conduct. And their initial estimation was to the tune of around 13 million transactions per calendar year. But in reality, what happened is it turned out that, lo and behold, when you put roadblocks up to people actually exercising their Second Amendment rights, they look for either alternative means or potentially bulk purchasing, so they don't have to go through the checks as much. And so in reality, the actual number of transactions that was occurring was about less than 10% of what DOJ originally estimated. And so coupled with the loan that DOJ took out to create the system itself was effectively underwater, and it was not able to financially sustain itself. And given California's current budgetary issues, it's no surprise that DOJ went to the legislature for first the statutory authority to adjust the fee, and then shortly thereafter propose regulations to increase the fee, which they now have done, and which that change has now been implemented. And so that's really the impetus for this increase in this fee, is that the system itself is not able to financially sustain itself because, people are, like I said, they're either in bulk purchasing ammo or otherwise just even not potentially purchasing ammo anymore because of the systems and roadblocks that DOJ has put in place. And as I suspect it will continue with this increase in the fee going from $1 to $5, it's now going to result in even fewer numbers of transactions per year and further further create this negative uh, income revenue system that's going to ultimately, maybe collapse under its own weight. Who knows?
And we'll see who thought that Gavin Newsom and his legislature would be bad at budgeting. I guess we did. We've been talking about it for a long time. It's not just this. It seems like every turn, the wrong decisions are made when it comes to financial responsibility for this legislature and the state, which is why we have the declared budget emergency that we have now. A lot of negativity there when it comes to, and this coming from a guy who we're all assuming is going to be running for president. A lot of bad turns made there. I've really got two questions on this that I thought would be worth addressing. First of all, what is the process by which this change actually came? From $1 to $5? Was it a legislative process? Was it a Department of Justice process? How does it actually go from 1 to 5?
Yeah, so it's both, and there's a statutory framework which DOJ gets to work under, which was, as you mentioned, the original Proposition 63, and what that effectively did was create California statutes that allowed this system to come into effect. But as part of that, there's also statutory authorization for DOJ to charge a fee for the actual costs associated with the check. And so originally that statutory fee was set at $1. But then obviously with the budgetary issues that we've seen with the system, DOJ went back to the legislature and basically asked them to amend that provision so they would then allow DOJ to create regulations to implement this higher fee, which is what DOJ recently did. And so DOJ, through their regulatory authority, proposed changes to the actual fees. And then, of course, following the regulatory process in California, those regulations have now taken effect. And pursuant to those regulations, this change in the fee from $1 to $5 was scheduled to take effect on July 1st today.
And that sort of begs the question. So if you have legislation that basically says, DOJ, you have the authority to change this, which is the legislative part, and then the DOJ just has that authority. I mean, I guess I would challenge you or anyone to think of a tax in California that went down for the taxpayer. I can't think of any. However, theoretically, could this change? Is there a way to undo this in the future, or does this? It seems like it doesn't necessarily have to stick, is what I'm saying. If the authority lies with the DOJ, could it change up or down in the future?
Yes, in theory it could, but that would require the DOJ to enact another regulation to lower the fee at that point. And you bring up a good point regarding the tax, as you mentioned. This is in addition to the tax that people have to pay as a result of AB 28 from the previous year, the 11% tax on firearms and ammunition. So in addition to the $5 fee, you're also having to pay an 11% tax on top of sales tax just to be able to purchase ammunition. And so you're right. As far as I don't think it's going to be within our lifetime that this goes away unless through, some court decision that holds this system unconstitutional, unfortunately.
Well, we've got that in the works, and obviously we think that we have the winning argument, so it's just a matter of time by which we can get that through the courts. But the final question is, they implement this for a reason, right? Or at least for a stated reason. Whether or not their intentions support that stated reason or not. The question is, and I know that you're somebody who really looks into this stuff. I'm just sort of curious. Has this helped at all? Another thing that we've been talking about for a while is how, the anti-Second Amendment legislators seem to have this cycle that they go through. They create legislation that creates a problem, and then they create more legislation that they tell us is going to help fix that problem, but really all that it does is aids and abets that problem so that they could come around and make more legislation. To me, and I know I'm not the attorney here, but that sort of seems like the cycle that we're in. They tell us that they are going to crack down on criminals by creating this background check, And then in order to support that background check system, now they're charging us more money. At some point, somebody has to ask the question, is the background check system actually catching criminals? Do you have any indication that this is working or none?
Yeah, and so DOJ actually made it a point to try and tout the effectiveness of their system when it was first launched. But as of late, not only do we have the budgetary issues in California, that also means we have, lower budget for things like general law enforcement. And so I have not seen lately the DOJ tout the effectiveness of this system in any way, shape, or form, like at least like they tried to do when it was initially launched, to obviously garner, support for the system in the first place. And so it begs the question. It's like, look, if you're a criminal, you're not going to go to a gun store to buy ammunition. You're going to find other means of buying ammunition. And so this system, in reality, all it's doing is it's creating a burden for law-abiding gun owners to be able to exercise their Second Amendment rights, plain and simple.
Which would be, I guess, the distinction of intention versus stated purpose behind a bill, or when you have that cycle, it's pretty easy to tell people this is going to cut down on criminality. But if you are of a specific political ideology, you don't want guns, this is the way that they do it, you guys. They tell you that they're going to cut down on crime, but in actuality, they're just limiting the rights of law-abiding citizens. But definitely something that we're going to watch and follow along on. This is directly tied to the Rhode v. Bonta lawsuit, guys. So another thing to follow along with there. We're going to be probably hitting you back up, Matt, when we get more info on the Rhode v. Bonta lawsuit to talk about that. But there is another lawsuit that I wanted to touch on. It happened. We got an opinion in it last week. That of course is the NguyenVBonta lawsuit in connection with some legislation that we've got going on in California. I thought I'd get your opinion, but could you actually, for those who haven't been following along, just kind of give us a little bit of a lead up, not necessarily to the NguyenVBonta lawsuit, but the 1 gun a month rule in California, before we actually get into the opinion for NguyenVBonta. Could you give us the lead up to that?
Yeah, so actually it was quite a while ago. This law, as we had in effect, was originally challenged in another lawsuit. I believe it was Sylvester v. Harris, a number of years ago now, probably over a decade ago or so. At the time, it was a restriction on handgun purchases. Of course, the legislature, through their infinite wisdom, has decided to extend the restriction now to try and apply to all firearm purchases in the state of California. And of course, that was challenged following the Bruen decision, which we didn't have in the original Sylvester case. And so now, thanks in part to the Bruen decision, we were first able to obtain an injunction against the law at the district court level, which was at least temporarily stayed. But then the Ninth Circuit allowed that injunction to take effect. And so for a while, we were able to purchase firearms without that injunction in effect. And then, of course, we had a argument at the Ninth Circuit, which the DOJ attorney had, a difficult day, let's just say, arguing the state's reasons for the law in the first place. And ultimately, we got a very favorable ruling out of the Ninth Circuit here, holding that this law is unconstitutional under the Bruen standard, which we now have.
Yeah, and I think that's important to understand, guys. We are still continuing to get wins that really originate from Bruen. This is something that was challenged several times prior to the Bruen decision from SCOTUS. Didn't necessarily go our way. This is more clarification into how we look at Second Amendment cases through Bruen and end up getting a different result. So we did get the NguyenVBonta opinion from the Ninth Circuit. It did rule in favor of the Second Amendment community, stating that the 1 gun a month rule in California was unconstitutional. Jacob, if you could actually pull this up. Matt, I wanted to get your thoughts on a couple things that I saw in this opinion. From the summary, it reads like this. California has a 1 gun a month law that prohibits most people from buying more than one firearm in a 30-day period. The district court held that the law violates the Second Amendment. We affirm California's law is facially unconstitutional because possession of multiple firearms and the ability to acquire firearms through purchase without meaningful constraints are protected by the Second Amendment, and California's law is not supported by our nation's traditions of firearm regulations. Just really quick, if I want to focus on one thing very specifically. multiple firearms and the ability to acquire firearms through purchases without meaningful constraints are protected by the Second Amendment. So I guess, Matt, they talked about a couple of things in this law or in this opinion. First, they said that it was a facial violation. And second, they said that the tradition of the United States does not support the law. For those, again, we've touched on facial versus as applied violations before. We've done a lot of talking about the tradition because history and tradition is kind of the Bruen standard. But can you go over both of these? What is a facial versus an as applied violation to the Second Amendment, and speak to the standard of tradition for looking at these lawsuits?
Yeah, so effectively, let's start with the facial challenge. If a plaintiff is, or a number of plaintiffs are filing a facial challenge to a particular law, what they're effectively arguing is that the law is unconstitutional under any circumstance, regardless of the circumstances as applied to the initial plaintiffs. And so, should that challenge be successful, the law in and of itself is unconstitutional on its face. So regardless of the particular circumstances, that would be a facial challenge. And so that law would no longer then be enforceable. An as applied challenge is a little bit more limited in the sense that you aren't necessarily challenging the constitutionality of the law in and of itself. What you're doing is you're challenging the constitutionality of the law as applied to the particular plaintiff's situation. And so, for example, you can get what we're seeing a lot of these types of cases, and we've seen recently, are things like challenges to the domestic violence restrictions or some sort of specific state felony that in other states would be considered a misdemeanor or something like that. And so what it's doing is it's an as-applied challenge, is saying, yes, this law is constitutional, but as applied to the particular circumstances of this plaintiff, we're holding that it's not. And so that's really the key distinction between the two. Regarding the historical analogs question that you had asked, as a result of the Bruen decision back in 2022, we now have this standard for how courts are supposed to analyze Second Amendment challenges, whether it be an as applied or a facial challenge. And so what the court is going to do is they're first going to look at whether the law impacts the Second Amendment right. And if it does, they're going to try and say, okay, if this law impacts the Second Amendment, is there some historical analog that can be related to the law that's being challenged here that shows that, it's within our nation's history and tradition of regulating firearms in this way? And if there isn't, then the court's going to find that the law in and of itself is unconstitutional in that situation. And so in this case, we have the California restriction on purchasing more than one firearm in a 30-day period. And I think that there was some good language here that says that although Bruen does not require a historical twin for a modern firearm regulation to be constitutional, the historical record in this case, the case challenging the 1 and 30-day restriction, does not even establish a historical cousin for California's one gun a month law. And so there is the record that was before the court, there is no, historical twin analog, as far as the court was concerned. Any sort of regulation that was enacted at the time of our country's founding or the ratification of the Constitution that suggests that we have regulated firearms in this way in shape and form in the past. And so that's why the court in this case ultimately held that the law that California was trying to enforce was unconstitutional.
And it does end up being a big victory for us to get this opinion from the Ninth Circuit. We'll see whether or not it gets appealed up to an en banc panel, not necessarily out of the ordinary for that to happen, at least in the Ninth Circuit, or up to the Supreme Court. But for now, a victorious opinion from the Ninth Circuit on the NguyenVBonta. But now let's shift over to, and I think it's important to get those standards understood and set correctly, because now we shift over to legislation, whereas the current law is 1 gun a month, even though it's not being enforced throughout the litigation process. The current law is 1 gun a month, and we now have Assembly Bill 1078, which is proposing 3 guns a month. And I guess to set this up even further, I wanted to pull from the NguyenVBonta lawsuit one more time. Jacob, if you could pull this up. It reads like this. California suggests that the Second Amendment only guarantees a right to possess a single firearm, that the plaintiff's rights have not been infringed because they already possess at least one firearm. California is wrong. The Second Amendment protects the right of the people to keep and bear arms, plural. This guarantees the individual right to possess and carry weapons, and not only is arms stated in the plural, but this term refers to more than just guns. It includes other weapons and instruments used for defense. California's interpretation would mean that the Second Amendment only protects possession of a single weapon of any kind. There is no basis for interpreting the constitutional text this way. For these reasons, we easily conclude that the plain text of the Second Amendment protects the right to possess multiple firearms, and we are not alone. The D.C. Circuit held that limiting the number of firearms of an individual can purchase or register within a 30-day period interferes with the individual's undoubted constitutional right to keep and bear arms, plural, in his or her home. I guess the question is, you could try to interpret the word plural when you move from 1 gun a month to 3 guns a month. I guess overall, my question to you is going to be, does language from this lawsuit potentially affect the legislative process of passing this bill? And even in a more pointed fashion, I don't really see anything in here that would limit this opinion to 1 gun a month. Assembly Bill 1078 proposes a rule of 3 guns a month. How would this majority opinion striking the 1 gun a month rule down not affect legislation like this?
Well, so it could be, for one, that, it's a different rule. And so California could be trying to weasel out of the opinion to the extent that it can. So, for example, if the opinion says the 1 gun per month restriction is unconstitutional, well, California comes back and says, okay, well, then we'll change it to 3. And so I think the problem with that is that, as the opinion makes clear, it's not like there's a set number that California is okay to regulate to. And so that's number one. But number two, the legislation that you're referring to does include a provision that states that it will not take effect unless the opinion here in NguyenVBonta is later overturned. For example, as you mentioned, they're going to be seeking an en banc review, which is basically an 11-judge panel review of the 3-judge panel decision. Whether or not the Ninth Circuit decides to do that or not remains to be seen. But nonetheless, should this opinion stand, then that legislation that at least is being proposed, from what I understand of how the bill is written, would not take effect.
I feel like, does that not make the bill even worse? Can you think of one piece of legislation that's been proactive in that manner? You're basically saying, I have so much faith in activist judges on the Ninth Circuit Court of Appeals that this is going to be that this opinion is going to be struck down. Our law is going to be considered constitutional, that when that happens, this law is going to take effect. Do you have any semblance of legislation that's been legislated that way?
It is unique, let's just say. But I will, to be completely honest, the Ninth Circuit, very often has ruled on Second Amendment issues in an en banc panel fashion when the 3-judge panel did not go the way of California. And so obviously, I think the legislature here is hoping to bank on that maybe that's what happens here. But, it remains to be seen. And so you're right. It is something that it's unfortunate of the politics that we have here in California being extremely hostile to Second Amendment issues generally, to try and sort of preempt or anticipate legislation because, for the most part, California has a very friendly court system here in the Ninth Circuit that has often routinely upheld their laws as constitutional, and often in doing so, bending over backwards, sort of engaging in legal gymnastics to uphold the constitutionality of a law, which they will probably continue to do absent some substantial changes of some type. So we'll see.
Well, so yeah, exactly. We'll see. Certainly a lot to follow along with here, you guys. Again, that 400% increase takes effect today. So if you are going to a gun store, that fee for the ammunition background check will be $5 instead of $1. Something to follow along with. Connected to that, though, is the Rhode v. Bonta lawsuit. We're going to be giving you updates here as we continue to progress through that litigation. And then, of course, we want to follow along with Assembly Bill 1078. But good news on the NguyenVBonta lawsuit, as they have opined in our favor on that one, in favor of our constitutional rights. So something to follow along with the legislation on AB 1078. We're going to be doing that, as well as we'll be seeing if NguyenVBonta gets appealed either to the en banc panel of the Ninth Circuit or the Supreme Court. All of this to say, Matt, thank you very much for the interpretation for us today. Really appreciate your time. Thank you for coming on and sharing. I appreciate it.
Thank you for having me.
Absolutely. And guys, one more time, please be sure to like, share, and subscribe to these videos. Throw your comments down in the section below. We're celebrating our 150th year of existence here at CRPA, and we're doing it at a great time. We've got Bruen backing us up. We're moving this litigation through the courts. We're knocking back a lot of legislation up in Sacramento. Let's keep the ball rolling, get this out to as many people as we possibly can. Thanks again, guys, and we'll see you on the next one.